There are 9 legal stages to getting your startup acquired, and in my experience guiding companies through acquisitions from the first conversation to the final wire, most founders have no idea about the specifics of each step, and therefore make mistakes that often cost them millions. You see, as someone who runs a law firm that helps startups raise and exit, I've watched founders receive $40 million offers and walk away with a fraction of that number once the earnout structure, escrow holdbacks, and indemnification claims settle out. So in this video, I'm walking you through all 9 steps of the M&A process, and I'll go over exactly what you need to know at each stage to maximize your exit value and avoid the common mistakes. Let's get into it. Step 1, decide to sell and know your number. Before any conversations start, you need to settle 2 things: whether you genuinely want to sell and what your number actually is. Founders who go in half committed end up taking meetings, sharing financials, and wasting months before pulling out, which costs you credibility with buyers you may want to come back to later. Now, for the number, there's a lot that goes into determining valuation, but you have to ground it in something real, like revenue multiples, EBITDA multiples, or comparable exits in your space. You want to talk to advisors who know your market and make sure your figure reflects what similar companies have actually sold for. And bring in your M&A lawyer before any outreach or marketing starts. Your company's legal health directly affects your valuation, and anything that hasn't been cleaned up will surface during due diligence. Things like missing IP assignments, unexecuted contractor agreements, and unresolved convertible notes. And if you have a board of directors, fiduciary duties apply, which means you're legally obligated to run a fair process and pursue the best reasonably available price for the company and its shareholders. Speaking of which, if you're thinking about selling your startup and you want experienced M&A counsel walking you through every stage of this, click the first link in the description and book a free consultation with me. Now let's keep going. Step 2, hire a banker. Unless a buyer is already at your door, you want an investment banker or a broker managing the process for you. This is because a good banker markets your company, qualifies buyers, manages the timeline, and most importantly, creates competition. And competition is what drives your price up. The legal document you're going to have with your banker or your broker is an engagement letter, and a few clauses deserve careful attention before you sign. First is the tail period. This is the window after your engagement ends where the banker or broker still earns their fee if you close with a buyer that they introduced. And tails can run 12 to 24 months, so make sure it only covers buyers that they actually brought to the table. Watch the exclusivity clause too, because some bankers want exclusive rights to sell your company, meaning even if a buyer finds you independently, they still get paid. And pay attention to how deal consideration is defined in the fee calculation, because some bankers calculate their percentage against total deal value, including earnouts and escrow holdbacks, which can significantly inflate what they collect. Step 3, market your company. Your banker puts together 2 marketing documents to take to buyers: a short anonymous teaser and a confidential information memorandum, or a SIM, that goes deep on your financials, team, and growth story. The goal is to get as many qualified buyers interested as possible, because more interested buyers means more leverage on price. Before any buyer sees the SIM, they're going to sign an NDA, and in M&A, the NDA matters more than most people give it credit for. This is because you're about to share your most sensitive information, including customer lists, financials, and trade secrets. So the NDA needs a non-solicitation provision to prevent buyers from using this process to poach your engineers. If you're dealing with a large strategic buyer, you also want a standstill provision that prevents them from making an unsolicited public offer and disrupting the process you're running. And the NDA should require the buyer to return or destroy your information, because if the deal falls through, you don't want a competitor sitting on your financials indefinitely. Step 4, get and negotiate the LOI. The LOI, which stands for letter of intent, sometimes called a term sheet, is the document where both sides agree on the big picture deal terms before either spends serious time or money on the full legal process. Most of it is non-binding, but the no shop clause almost always is binding, which means once you sign, you're locked in with that buyer for 30 to 90 days and you can't talk to anyone else. One of the most consequential elements in the LOI is the deal structure, meaning whether this is an asset purchase, a stock purchase, or a merger. This is because each structure has completely different tax, liability, and operational implications for you as a seller. In an asset purchase, the buyer cherry picks what they want and can leave your liabilities behind. But in a stock deal, they're buying the entire entity, including everything that it comes with. And if there's an earnout in the LOI, that needs to be negotiated carefully before you sign. An earnout means part of your purchase price only gets paid if this business hits certain performance targets after closing. But once you've sold, the buyer controls the company. This is because they can redirect resources, cut your team, or change strategy in ways that make those targets impossible to hit. And without the right language in the acquisition agreement protecting you, there's very little recourse. Step 5, due diligence and the acquisition agreement. After the LOI is signed, the buyer's legal team sends over a due diligence request list, which covers corporate records, contracts, IP documentation, financials, tax returns, employee agreements, and litigation history. You build out a virtual data room and start uploading documents, and if your legal house was in order from step 1, this moves fast and builds the buyer's confidence. If it isn't, things slow down and get expensive, and the buyer starts wondering what else is wrong. While due diligence is running, the buyer's lawyers are also drafting the definitive acquisition agreement, which is the binding document that governs what's being bought, what's being paid, and who's responsible for what after closing. Whether it's called an asset purchase agreement, a stock purchase agreement, or a merger agreement depends on the deal structure, but I'll refer to it as the APA for the rest of this video since the core concepts apply across all three. Step 6, negotiate the APA. The APA negotiation is essentially one big exercise in risk allocation between you and the buyer, and reps and warranties are where most of that risk lives. Reps and warranties are factual statements you make about your company, like owning all your IP or having no pending litigation, and if any turn out to be inaccurate, the buyer has a claim against you after closing. So your job as the seller is to qualify every rep you can, and the phrase "to the seller's knowledge" does a lot of work throughout this part of the process. Once reps and warranties are drafted, the indemnification section defines your exposure if something goes wrong. The cap is your total potential liability, typically 10 to 15% of the purchase price for general reps. Then there's the basket, which is the amount the buyer has to absorb before you're on the hook at all, similar to a deductible. And the survival period is how long the buyer can bring a claim against you, usually 12 to 24 months for general reps and longer for fundamental reps like ownership and authority. Beyond that, the escrow terms and the material adverse effect clause are the two other areas to lock down. Escrow is typically 5 to 20% of the purchase price, held back after closing to secure indemnification claims, and as the seller, you want that number small and released quickly. The MAE clause defines what counts as a catastrophic change to your business between signing and closing, and you want carve-outs for general economic downturns, industry-wide changes, and the effects of simply announcing the deal. Step 7, disclosure schedules. Disclosure schedules are the companion document to your reps and warranties, and this is where you list every exception to every statement you've made about the company. So if you represented that there's no pending litigation, but there's actually a small dispute in progress, that gets listed here, and items that are properly disclosed generally can't be used against you as a breach after closing. Rushing through this step is one of the most common mistakes I see in the final stretch of a deal. Founders are exhausted and they want to close, so they get vague or skip things. But a missed disclosure is a potential indemnification claim waiting for you after closing. And your reps need to be accurate at closing, not just at signing. So if anything material changes when you sign and when you close, you need to update your schedules. Step 8. Sign, close, get paid. In some deals, signing and closing happen the same day, but in others, there's a gap of 30 to 90 days while the conditions to closing get satisfied. Conditions typically include confirmation that your reps are still accurate, third-party consents from key customers or landlords, regulatory approvals, and sometimes shareholder approval. Closing day involves a significant stack of documents, and the one founders always ask about is the non-compete. Buyers require you to sign one, typically covering 2 to 5 years across your industry and geography. States like California generally don't enforce non-competes, but there is an exception in the M&A context when the seller receives substantial consideration for the sale, so don't assume you're protected just because you're in California. The other thing to understand before closing is the working capital adjustment. Most deals include a mechanism where the business needs to have a target level of working capital at closing, and if the actual number is above or below the target, there's a cash true up 60 to 90 days after closing. Working capital disputes are one of the most common post-closing fights, so make sure the target and the measurement methodology are locked down in the APA before you sign anything. Step 9, transition and earnout. After the wire hits, the buyer needs your help running the business, and that relationship is governed by a transition services agreement, or TSA. The TSA defines what you're providing, for how long, and at what cost, and transition periods typically run 3 to 12 months. If you have an earnout, the next several months are when it all plays out, and your leverage depends entirely on what you negotiated in the acquisition agreement. The agreement should require the buyer to operate the business in good faith in a manner consistent with achieving the earnout targets. Because without that language, they can redirect resources, cut your budget, and reassign your team without any obligation to protect your ability to earn out. You also want a dispute resolution mechanism specifically stating that disagreements about whether targets were met go to an independent accounting firm, not the buyer's internal finance team. And consider negotiating acceleration clauses, meaning if the buyer terminates you without cause, materially changes the business, or breaches its earnout obligations, the full remaining earnout pays out immediately. So if you're thinking about selling your startup and you want experienced M&A counsel walking you through every one of these 9 stages, go ahead and book a free consultation with me by clicking the first link in the description. We'll go over your specific situation, look at where you are in the process, and map out exactly what you need to do to protect yourself and make sure the number that hits your bank account is as close as possible to the number that was on the table. Again, you can book that free consultation by clicking the first link in the description. And if you want to understand what this whole process is going to cost you in legal fees, watch this video next.